But before we go on the record, is everybody here? Okay. We had a panel change. I just want to note Jeff Njija is being replaced by Amanda Vassig. Secondly, apparently you sent in a letter that you wanted to add some, or just you wanted to note the evidence you want to submit. And I think I gave you guys a list of exhibits 1 through 22, and you mentioned in your letter that you want all your exhibits and your affidavit briefs in. So I was wanting to suggest that we add all your briefs, which appear to be affidavits because they're signed under penalty of perjury, as additional exhibits, just to make sure they're in the record. So if FDB doesn't have any objections, I would add his exhibits. I think there's 5 briefs that are affidavits. One's December 27th, 2017, August 29th, 2018, December 13th, 2018, March 15th, 2019, and October 5th, 2019. Those are just his briefs, and just to add those to the exhibit list. Does FDB have objection? Or? No. Okay, then when we go on the record, I'll introduce appellant's exhibits as 1 through 27. Then we have those included, and all the exhibits are in the record. And the rest of them should be all the exhibits that you submitted with the briefs. And I didn't think that we had any objections. Is that still true to any of the evidence that's being admitted to the record? Okay. Well, okay, yeah. Well, we have FDB's exhibits A through R, which will into the record, and then we'll decide the weight to give them. Stenographer, you ready?
Is his mic on?
Oh, there we go, green light.
Okay.
Yes.
Okay, then let's go on the record and get started. We are now on the record in the Office of Tax Appeals oral hearing for the appeal of Stephen E. Reed, number 18042786. We're in Fresno, California. The date is Thursday, November 21st, 2019, and the time is 10:25. My name is Josh Lambert, and I'm the lead administrative law judge for this hearing, and my co-panelists today are Suzanne Brown and Amanda Vassig. Appellant, can you please identify yourself for the record?
Stephen E. Reed.
Thank you. FDB, can you please introduce yourselves for the record?
Good morning, Your Honors. My name is Ellen Swain. I represent the Franchise Tax Board along with Maria Brosterhouse.
Thanks. The issues in this appeal are whether appellant established error in the proposed assessments for the 2014 and 2015 tax years, whether appellant established a basis for abatement of the late filing penalties for the 2014 and 2015 tax years, whether appellant established a basis for the abatement of the notice and demand penalties for the 2014 and 2015 tax years, and whether the Office of Tax Appeals should impose a frivolous appeal penalty. The parties agreed to the admission into evidence of appellant's exhibits 1 through 27 and FTB's exhibits A through R, and neither party had any objection, so I'll hereby admit those exhibits into the evidence. We will begin with appellant's arguments first, and you'll have 15 minutes to give your presentation, after which FTB and the judges will ask questions if they want. Then FTB will make its presentation for 15 minutes. You can ask questions, and the judges will be allowed to ask questions. After that, appellant, you can make a rebuttal for 10 minutes. And please try to speak slowly, both parties, so the stenographer can record what you state because she'll be providing a transcript after a couple of weeks. And appellant, you want to be sworn in, I believe. Is that correct?
Yeah, everybody will need to be.
Okay, well, you can be sworn in, but the FTB said that they won't be sworn in because they're not going to be presenting as witnesses only arguments.
Well,
So-
they can't present any arguments if they don't have witnesses.
Well, they don't need to.
Sorry.
They're providing exhibits, and that's what we're looking at in the record. Whereas when you provide your testimony, that provides the ability for us to use your testimony as a finding of fact. So what you state may carry more weight than their arguments. So we'll just have you swear in, and that's it. So stenographer, can you please swear in the appellant?
Please raise your right hand. Do you solemnly state or affirm that what you're about to say is the truth, the whole truth, and nothing?
I certainly most do.
Okay, thanks. You have 15 minutes.
Okay, I also like to bring forth that the copy that I received from Ellen on October 16th prior for the exhibits of A through R, I believe that's been recorded. Also, to let the record note that it's bringing forth the years of 2010, 2011, 2012, and 2013 as well. So any and all of the exhibits that I have filed also addresses that within a timely fashion per the state and federal rules of civil procedure. You have apparently the records, and you've gone over it, so I have questions for you of a panel of three. Have you gone over the briefs and
Yeah, we've read all the briefs, but I would use this opportunity to present your argument instead of asking us questions. This is your time to present your argument, so we're here to listen to what you have to say.
Well, I've submitted under affidavit and oath of all the evidence of fact from the other agencies and of myself. So for me to go over it, the only thing I can state would be is that to know that you have and read my responses
We
to
have.
a claim of someone, don't know, as pursuant to the federal and state rules of civil procedure.
Yes, we've all read all of your briefs and your evidence.
Okay,
so.
are you familiar with 18501?
I'm not sure, but what you're I'm not sure what you're saying, but I would present your argument, explain to us what you want to say, and then we can.
Well, what I want to point out is that any of the evidence that they brought forward, they've made claim of being part of an identifying entity of some sort or some kind. My evidence has shown that I am not. And the first paragraph of 18501 of the RNTCs clearly takes, with my evidence, provides the fact that I am not every individual taxable under Part 10, commencing with Section 17001 through whatever it is. They have not presented any evidence of being part of a claim to even be able to be claiming a frivolous penalty, because the frivolous penalty is then for businesses or self-employed or whoever it may be. The evidence that I have presented is under fact, and that I have not any one of what they have claimed. So under even the state rules of civil procedure, under the evidence codes, my evidence is overwhelming. They haven't rebutted any part of it. So I stand on my evidence and my claim of fact, and for anybody to rebut it and to be charged with something, they will have to have a greater weight of law or of evidence to do so. I stand and set in honor, and I stand and set before you that everything he submitted is on the record and of the truth and of fact. Claims cannot be within any tribunal. They don't stand. I yield my time.
Okay. FTB, do you have any questions?
No, Your Honor.
Judges, do you have questions?
I do not. I do not.
Okay, FTB, you have 15 minutes to make your presentation.
Thank you. The Franchise Tax Board has established that its estimate of income in Mr. Reed's case was reasonable and rational. Once we establish that, the burden shifts at that point to Mr. Reed to establish where it was erroneous. And he has not shown that. His pleadings do not show that. Likewise, the demand penalty and the delinquent filing penalties were both properly imposed in this case for 2014 and 2015. And finally, the issue of the frivolous appeal penalty that's before this court, it's it's the agency's penalty to impose. The reason we brought it to your attention is that it would appear to be warranted, given that in a precedential opinion by the OTA in the opinion of Balch, it found that wages were taxable and they did impose a frivolous appeal penalty. It also appears to be potentially brought along in this case to create delay because the taxes have not been paid. In the case that if there's any questions, I'm happy to answer them.
Thank you. Judges, do you have any questions?
No, I do not.
No, I do not.
I do not have any questions.
Okay. Appellant, did you have any questions?
I want to enter into the effect of objection to what she has testimonied or claimed. The record shows that I filed on a proper date and proper time. They were mailed by the United States Postal Service on the proper date and received. There was also accompanied forms that they are not acknowledging to rebut anything of what was falsely paid. And there is evidence of that as well, to where the payers have not even been brought in here as witnesses to be presenting their signature of fact under a W-2 or of a P3 or whatever, 33 or 34 or whatever those are that they file, and whoever it is that signs it to state that. So again, a false claim that has already been rebutted by even their own filings. That's within the record of OTA of my mailings. I filed on time, and there is no corrections or anything on those forms. They're filled out just exactly how they're supposed to be and signed. So for anybody to come forth with anything that's different than what was said and what was done, the evidence of fact is there, that there was no, how did she say, delayed or not received in time. Sorry. The evidence is all there. It's fact.
Okay, thank you. So I guess that would be your rebuttal. Do you have anything else you want to add?
I just hope the law is followed out here, because I've got some other information here about these whole proceedings, and it's kind of bottling, and I'm not wanting to bring it to your attentions, and this is not the time or place, but it just balls me that I can be held for something that I am not. And then for anything like earning withholding orders to be taken and done without due process. It's the truth. There was anything and everything was taken without due process before this date, and we're talking 5-6 years ago even. Never, I've got responses all by either certified mail or certification of mailing. It's all been put in the record, and I've responded. They never even looked at this. I've talked with, well, why isn't the plaintiff here? Which would be Royce Larson or M. Jennings. They're the ones who signed the frivolous penalty. That was the first thing I get back in the mail once I mailed it on the 12th of April. I respond. They never come back. They never even acknowledge when I talk to him on the phone. He never acknowledged a 4852 or a 3525. That is the lawful form that they say, and it says right on it, to fill it out and send it in on any kind of dispute. It's on the record. They have sent it in. I've sent it in. There's no delay. There's been they call them EWOTs several times, taking my funds, putting my family in deep jeopardy when, okay, enter into an agreement for hardship. No. That's an agreement. I never even willingly, knowingly, and intentionally entered into an account That's stated here too. There's no evidence of such account created knowingly, willingly, and intentionally. That means I have a business. That means I have some sort of business part of the state of California or some county or somewhere else. All the evidence shows I'm not any part of them. I'm not a fiduciary. I'm not a trustee. I'm not collecting any of that kind of stuff. So then what am I? I'm a private citizen. So what I would expect is that the truth and the law to be brought forth, and I would think it would be brought here at this quorum to show me where I'm wrong, or at least rebut to show where it is that I have. Because right now all the evidence shows that I have not, and there has not been any lawful, under oath, or certified rebuttal. And that's what the laws are created from under the Constitution, to the United States codes, to the federal rules and state rules of civil procedures, for those authorities to follow to proceed against a private. I expect it, please. Thank you.
Thank you, Mr. Reed. So at this point, I'm going to close the record and conclude the hearing. And I want to thank both parties for coming in today. Following this hearing, my co-panelists and I will discuss the evidence and argument, and we will issue a written opinion within 100 days. Thank you. This hearing is now closed. And it'll probably be 5 minutes before the next hearing begins. Thanks.
Thank you, Your Honors.
Will I be able to order a transcript?
Maybe you should talk to Dana Holmes, the ombudsman.
That'd be cool. I'm sorry? Oh, yeah, I wanted to get a transcript of this when it happened.
So we'll post the transcript online.
Okay.
But if you leave an email, if you leave an address, we'll email it to you, we'll mail it to you as soon as it's public.
Sure. I can leave you an address. Yeah. Get a rubber band around it so you can.
Or you can email us your address.
Yes, it's right across the hall.
Yeah, that's all.
It's locked, but if someone else is going in, you can just follow, or Dana has a key card. Okay, because our OTA cards don't.
Oh, okay.
I don't think they do, no.
And you just want to
I didn't expect them to, but
Right.
Mike told me he would.
Can we email it to you, or would you prefer it be mailed?
I'd prefer it to be mailed. The printer I have, it doesn't have very much.
I'll send it out. It takes a couple weeks to get transcripts. So when it's complete, we'll have it.
Thank you so much.
It was some sort of.
She had a.
I'll put you closest to the mic. How about that? Oh, these are the, yeah, that's fine.
Did they bring up the leasing for everybody? Did they have them here?
I don't think so. No one offered me one.
Looking through everything. And I actually found in your prior lawyer's thing, he had this from the receiver. Lortz actually got back $484,000. Sure had that in his records. It was in the records that Fodger gave me. He emailed me a bunch of records. I thought that was interesting, at least. I mean,
And that's when I first found out about it. Was when he was gone.
oh, so just a couple years ago.
Yeah, yeah.
You need to be in the restroom. No, you can come back in this way.
Mr. Reed was saying up here. It wasn't terribly clear.
I don't think they understood either.
Yes. I'm not sure if he's one of those people who says the state doesn't have jurisdiction over him or something. I couldn't quite tell.
You can start whenever you're ready.
Amanda's in the restroom.
Oh, you better be perfect.
I will start when she returns. Yeah. Is everyone ready to get started in the hearing for Nathan Charles Lortz? Okay, panelists are ready, parties are ready?
Yes.
Okay, I think before we go on the record, I'll just mention, I think everyone's already heard the instructions about speaking clearly into the microphone and speaking slowly so that the court reporter can clearly take down everything that we say. So just please keep all that in mind. And if you're sharing a microphone, please make sure to pass it back and forth or lean or whatever you need to do so that what you say makes it into the microphone and makes it into the recording. All right.
Got to get in between us here. There we go. There we got you.
All right. Then if everyone is ready, we will go on the record. We are on the record in the appeal of Nathan Charles Lortz. This is OTA case number 180-11819. We are in Fresno, California on November 21st, 2019, and it is approximately 10:45 a.m. My name is Suzanne Brown, and I am the lead administrative law judge for this hearing. And my fellow co-panelists are Michael Geary and Amanda Vassig.
Good morning.
Good morning.
Okay. First, I will ask each party to identify everyone for the record. We can start with appellant. Mr. Brumfield, can you identify yourself and your client?
Yes, Robert Brumfield for appellant Nathan Charles Lortz, and Mr. Lortz is to my left.
Okay. And respondent.
Amanda Jacobs for the California Department of Tax and Fee Administration.
Stephen Smith.
And Lisa Renati.
Thank you. All right, I'm just going to briefly go over what the issues are in this case. They are the same as we confirmed during the pre-hearing conference and the same as I confirmed during my in my minutes and orders that you should have all received. Okay, so I believe everyone knows that there are two issues in this appeal. The first one is whether appellant is personally liable under Revenue and Taxation Code Section 6829 for the unpaid liabilities of Lortz and Son Manufacturing Company for the periods October 1st, 2009 through January 31st, 2010, and January 2nd, 2011 through July 31st, 2011. And the second issue is whether there is reasonable cause to relieve the penalties imposed on Lortz and Son Manufacturing that were included in appellant's liability under Revenue and Taxation Code Section 6829. I'm also just going to briefly confirm and correct me if any of that was mistaken or if I left anything out, but I'm assuming that that is all. That was all a correct recitation. Yes.
I was going to say the only thing when I was looking over.
Into the microphone.
I'm sorry. When I was looking over my notes, I noticed you're also referencing Revenue and Taxation Code 6592 for relief from penalties. That was as part of the discussion we had, and that wasn't specifically mentioned in the order, but maybe that's subsumed in the in item 2 that you recited. I'm not.
That is correct.
Okay.
That is the section, and I guess I just left it out for conciseness.
That's fine.
But yes, that is the basis for the relief of penalties is section 6592.
Okay, thank you.
Okay, and I'm just going to confirm in terms of which elements of 6829 are in dispute and which are conceded. That. We discussed during the pre-hearing conference, and I confirmed in my order that the elements that are in dispute are whether appellant had control or supervision of or was charged with responsibility for the filing of returns or payment of tax or otherwise had a duty to act for the corporation in complying with the sales and use tax law. We sometimes refer to that as for shorthand as element 3 or the responsible person element. And willfulness is the other element in dispute. And then regarding willfulness, there are 3 components, and one of them is conceded. That the component that's conceded is that appellant had actual knowledge that the taxes were due but not being paid. So the 2 remaining components of willfulness that are remaining in dispute are whether appellant had the authority to pay the taxes or cause them to be paid, and whether appellant had the ability to pay the taxes but chose not to do so. This is just confirming what we've already discussed, and if there's any correction or questions, please let me know. Otherwise, I will move on.
Can we stipulate to the elements that we won't be discussing?
Yes.
Okay.
And that's in my order as well, that the first 2 elements are conceded. So the termination of the business is conceded, and that the corporation collected sales tax reimbursement is also conceded, and then knowledge, as the knowledge component of willfulness is also conceded.
Those certainly things are all true. The only qualification I have is you'll hear Mr. Lortz testify a little bit about his time as so-called president of the company. There were a lot of taxes that were being paid. So the phrase about taxes due but not being paid is a bit broad.
I guess
Because over a 4-year period, a lot of taxes were paid. There were installment agreements. There were a lot of things that were going on. And this is sort of like an abject statement that taxes were not paid at all. That's all.
I will clarify that the issue that when I refer to the taxes, it's the taxes that are in dispute in this case, the taxes that were unpaid and thus are at issue.
Correct.
Okay.
At least not being paid in full.
Right.
I'll give you that. Because in 2011, for example, there were significant payments on some of the exhibits I received from the board show in 2 months well over $100,000 of payments, for example. So I just want to make that clear that it's not like someone just sitting there saying we're not paying it at all, but there's going to be some testimony in that.
And again, as I will clarify that when we are referring to the taxes that were not paid, it's only the unpaid portion. The paid portion is not in dispute.
Okay, fair enough.
Okay. So next I want to move on to, let's see. Oh, and I will also, I want to move on to the evidence. I just want to reiterate what we discussed at the pre-hearing conference, that I want to remind the parties that one thing that we do not need to address is whether appellant's motive was whether he had any intention to defraud the state. We discussed this at the pre-hearing conference, that is not at issue. And Mr. Brumfield, you indicated you understood that under Regulation 1702.5, Subdivision B2. I pointed you to it, I believe, that we don't need to spend any time, you don't need to spend any time establishing that Mr. Lortz didn't intend to defraud the state, because that's not part of what we're looking at here.
No, I understand that in principle, yes.
Okay. All right. And then I want to move on to the exhibits. You should have received the evidence binder that my office distributed electronically, and that contained respondents' exhibits A through E. Initially, we sent out A through D, and then respondents submitted Exhibit E subsequently. Okay. We discussed during the pre-hearing conference, Mr. Brumfield, we discussed whether you had an objection, and I said we would revisit it at the start of the hearing. Do you object to any of respondents' exhibits A through E being admitted into the record?
No, not admitted into the record. I recognize those are the business records of the department. I think there are some items that I'll comment on probably in closing as to going to the weight of the evidence, but not as to the documents themselves.
Absolutely. The weight of the evidence is something that the panel will be considering, and it is perfectly appropriate for the parties to make arguments about the weight of the evidence. Okay, so with that, I will admit respondents' exhibits A through E into evidence. All right, and as we also discussed during the pre-hearing conference, and I confirmed in my order, we will have only one witness today, and that is Mr. Lortz, who will be testifying. The appellant has the option to testify in a question and answer format. With Mr. Brumfield, you can ask him questions and he can respond, or he can testify in a narrative format. Do you know which format you're going to be using?
I was going to do question and answer.
Okay. And I will, before Mr. Lortz testifies, I will swear him in as a witness. Respondent is not calling any witnesses, but they will be making argument. And so the difference is that when the attorneys make arguments, they are not testifying under penalty of perjury, but when a witness testifies, it is under penalty of perjury, and that is considered evidence that the panel can consider. Okay, and then I'll just run through briefly our time frame and what we're looking at today. We're going to begin with appellant's presentation. As we discussed, that will not exceed 1 hour. Mr. Brumfield, if you have excess time, in order to encourage you to be concise, if you have excess time at the end of the hour, you can save that for part of your rebuttal.
Okay, thank you.
Okay. And do you also plan on making an opening statement?
No, I think we all know what the issues are and of what the tax liability issues are. It's really a matter of, I think, evidence and argument at the end, quite frankly.
Okay, thank you. And then once Mr. Lortz has testified, CDTFA will be allowed to ask questions, and the judges may also ask questions. Then CDTFA will make its presentation, and we discussed that will not exceed 15 minutes. And then there may be questions for CDTFA, and then appellant will have approximately 15 minutes to respond. And if anyone needs a break at any time, please let me know. Okay. So I believe that we are ready to proceed then with Mr. Lortz's testimony. Does anyone have any questions, or is there anything that I need to address before we begin with appellant's presentation?
No, I don't think so.
Okay. Mr. Lortz, if you would please stand and raise your right hand. Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Okay. Appellant, you may begin.
Okay. Excuse me. Mr. Lortz, when did you first become employed at Lortz & Son Manufacturing Company?
Approximately 2002.
What was your age at that time?
27, I believe.
Okay. What was your position at the company when you first started?
I was in sales.
And what could you generally describe your duties?
Bring in new orders, new business to the company.
How long did you stay in that position?
As a salesman, as a title of salesman, to about 2007, 2008, somewhere.
Did your duties as a salesman ever involve the handling of any finances for the company whatsoever?
No.
During this initial time frame working for the company, were you involved at all with any decisions concerning what vendors to pay or whether to pay certain taxes?
No.
During this initial period of time, were you responsible for reviewing or signing any of the company's tax returns?
No, sir.
When you started working at the company in 2002, do you recall the approximate sales volume of the company?
I believe it was about $4 to $5 million.
And when you transitioned out of your sales position in 2007 or 2008, do you recall what the approximate sales volume was then?
I believe 25 million.
For the time frame you were a salesperson, 2002 to approximately 2007, did the company have officers and a board of directors, to your knowledge?
I believe so, yes.
Do you know who the officers were in that time frame?
Well, I know my father was the president of the company, and I think Cynthia Schnur was the CFO at that time, and then there was a group of guys that were the board of directors.
During this time frame, 2002 to 2007, were you ever an officer of the company?
No.
During that same time frame, were you ever a director of the company who sat on the board of directors?
No.
Do you know who the board of directors were in that time frame?
I don't remember their names, no, sir.
Okay. Was your father one of them?
Yes. Yes.
Was an individual named Mike Coffey one of them?
I believe so.
I suggested a couple of names there. Do you remember any other names after?
Steve Anderson
Steve Anderson.
and Dennis Birch.
Okay.
and I believe John Lake.
Okay, thank you. During this time frame, 2002 to 2007, were you ever responsible for monitoring or directing payment of any sales taxes the company might owe?
No.
I understand in about 2007, you were asked to become an officer with the company. Is that correct?
I was told that they were naming me as the president. Yes, sir.
You were told that?
Yes.
Who told you that?
My father and Mike Coffey, who was our vice president at the time. Was the vice president of the company at the time.
Were you told that the board of directors had actually appointed you to that office position?
No.
Have you ever seen minutes of the board of directors where you were ever appointed to that office position?
No.
What was your response to being told you were going to become president?
Well, I grew up in the company. My grandfather started the company in 1945, and I grew up sweeping the floors, welding, learning the business. And so it seemed odd to me. I mean, I thought I was doing a good job in sales, and I said, why do you want me to become the president? And they said, well, your dad's getting older, and when you're selling to bigger entities, that it's more clout. It's easier for you to close the deal if you're the guy. If you're the president, then you can speak on behalf of the company in terms of closing that deal or committing the company to a sale.
I've seen various documents that were produced by the department that indicate during the time that you were supposedly president, your father was still chief executive officer. Were you aware of that?
My dad was there every day. It was his company. He was the guy.
But were you aware of him acting as CEO?
Yes, yeah.
Did your father when he told you you were going to be president, did he tell you he was going to remain as CEO, which at least legally is the functionally equivalent of being a president
Yes,
too?
yeah.
Were you provided, when you were told you were becoming president, were you generally aware of the financial condition of the company?
No.
Did any of the directors or other officers ever review with you any of the financial records of the company when you were told you were becoming president?
No. But that wasn't my responsibility. My job was to bring new orders, new work to the table.
Okay. Did that remain your job after the time you were told you were becoming president?
Yes.
So when you were told you were becoming president, did your duties as an employee of the company materially change?
No.
Did your salary increase?
No.
So you still just ran the sales arm of the company even though you had been bestowed the title of president?
Sales and production. Like I said, I grew up in the shop, so if there was a problem in production, then they would call me in to solve that problem, to figure out how to undo the problem.
When you when you were told you were becoming president, did the company have any issues regarding delinquent payment of sales taxes to your knowledge?
Not to my knowledge, no, sir.
Once you became president, did your father remain on the board of directors of the company?
I believe so, yes.
Did Mr. Coffey remain on the board?
Yes, sir.
How about Mr. Anderson?
Yes, sir.
Mr. Birch as well?
Yes, sir.
Was there another one I missed there?
Mr. John Lake.
Oh, okay, John Lake, yes, thank you. So they all remained on the board of directors after the time you were told you were becoming president. Is that a yes?
Yes, sir.
Okay.
Sorry.
Yeah. Were you ever appointed to be on the board of directors?
No.
At some point in time, did the company experience some financial difficulties which led to some sales taxes not being paid, or at least,
Yes, sir.
or not paid in full?
Yes, sir.
Do you recall what year that was?
I want to say late 2009, 2010, I believe.
Okay. So from the time that you were told you were becoming president, the company, to your knowledge, paid all of its sales taxes, at least up until this late
Yes.
2009, 2010 timeframe you're referencing?
Yes, sir.
How did the issue of not being able to pay the sales taxes in late 2009 to 2010 come up?
Well, so at the, I'm trying to remember to the best of my ability, but the company banked with Merrill Lynch out of Chicago for that. They were our financing. They were our bank, and Merrill Lynch. This was the beginning of the financial crisis, 2009, 2010, and Merrill Lynch. We no longer fit their model. I guess the best way to say that. And so they gave us, I think it was 60 or 90 days to find another banking institution. And in about that time, like let's say that our backlog of work, orders to be completed and billed, was averaged $20 million. Kind of overnight, our backlog went to maybe $5 or $6 million. And though, I mean, the writing, everything contracted. And so we were starving for cash, basically. And I know that our CFO, who then was a lady named Diana, we said that, I believe it was her, that said, we're not going to be able to pay our state sales tax, that I'm going to have to make an agreement with the state of California, a payment plan with the state of California at that time. And that's when I learned about it.
So was Diana Wee in charge of making the payment arrangement with the state of California?
Yes.
Did you carry on any negotiations at all yourself personally with the state of California for sales taxes?
No, sir.
Did you ever carry on any discussions at all with the state of California regarding negotiating payment of sales taxes?
No, sir.
Were those functions always left with Ms. Wee during that time frame?
Yes, sir.
Would she report back at some point that she had made an arrangement for payment or something like that?
Yes, I think that because I remember signing some basically the payment plan document that that she asked me to sign.
You don't, we'll talk about the receivership in a little bit, but from the time the receivership case was filed in late 2011, have you had possession of any corporate records, financial or otherwise, at all?
No, sir. I wasn't part of the company at that time.
Okay. Were those turned over to the receiver?
I believe so. Yeah. I assume so. I mean, that's, yeah. If you could restate that. So the documents of the company were turned over to the receiver?
Right.
Yeah. I mean, they had to be.
They were.
But I can't put my hand on my heart and say that happened, but
Okay.
I wasn't there when that happened, but I would assume logic would say that that's what happened.
Were any of the financial records or other records of the company ever returned to you after the receivership completed itself?
No, I had nothing to do with the closing of the business or the receivership.
Now, on this installment arrangement or payment arrangement you were talking about in regard to the 2009 to 2010 taxes, did Ms. Wee report back to you that she had been able to reach an agreement with the department?
Yeah, yes, I believe, yes.
Did she report back to you, or was there a committee in place to deal with the company's financial issues at that time?
There was a committee that we put together to basically a cash flow committee.
Who was on that committee?
So it was Diana Wee, Gene Polk, who was the head of customer service, Joe Grenier, who was the head of the product value team, which was basically purchasing, my sister, Amy, and Mike Coffey would often sit in those meetings. Periodically, my father would sit in those meetings, but we wanted him to be there, but he didn't want to be there. So
Referring to your dad?
yes, sorry. Yes.
When did that committee start meeting? Meaning, was it in 2009 or sometime before that?
I believe it was about 2009.
That was when the cash crunch problem started coming up you were referring to?
Yes, sir.
What was the purpose of that committee?
The purpose of the committee, I didn't have the financial background to navigate the company out of that water, and frankly, it wasn't, I think, my responsibility, but I don't have the relationship with the vendors that we need to pay. And those vendors, if you don't have constant communication, honest communication with those vendors, there's no way that you're going to move the company forward. And so we have to pay them something. So it seemed logical that we would have the people that had those relationships would come to that meeting and say, we have to pay company X $1,000 or $100,000 or whatever that was in order for us to keep moving these other projects forward. So it just seemed that worked better because there was so many things happening that not one person could control all of that at that time.
Were the issue of delinquent sales taxes discussed by the committee in that 2009 to 2010 timeframe?
I don't recall them being discussed other than knowing that we needed to allot, as Diana would put the cash flow projections, the weekly cash flow projections together, that we would allot the money in there to ensure that we were staying current with those obligations.
Did the committee ever make an affirmative decision not to pay sales taxes?
No. No, sir.
Did you ever direct Diana Wee not to pay the sales taxes?
No, sir.
So Diana Wee was, again, handling all the discussions and negotiations for the 2009 to 2010 sales tax timeframe and reporting those back to this cash flow committee?
Yes, sir.
And what she reported back on the payment arrangement that she had reached was acceptable to the cash flow committee?
Yes, I mean, she was a part of that committee, so she understood what needed to be done.
The other time frame and issue, Mr. Lortz, I want to orient you as to time in regards to unpaid or partially unpaid sales taxes is the year 2011, okay?
Okay.
Were you aware of was the cash flow committee made aware of a sales tax payment problem in early 2011?
Repeat that, please.
Was your cash flow committee made aware of a problem in regards to being able to pay the sales taxes in full in early 2011?
Not that I remember.
Who, had the committee's composition changed in 2011 at all?
There was a gentleman that was really the company's attorney, but he was really my father's attorney, a guy named Ray Mullen, had joined to help the committee. And I think that we had laid some people off. I think Joe Grenier and maybe Gene Polk were a couple people that were laid off just because of the tightening. The business prospect wasn't getting any better.
Do you recall when Mr. Mullen first started advising the company or this committee?
No, sir, I don't. I believe that it was somewhere around 2000. late 2010, early 2011 is my best guess.
I just wanted to, just for purposes of the record, just to correct something in the original, well, not original, the decision and recommendation that came out of the May 16, 2016 conference. There was a reference to Mr. Mullen being an accountant. Mr. Mullen was actually, he's a business attorney in Bakersfield. So just wanted you to know that he was not accounting assistants coming in. He was an attorney assistants. Now, what was so Mr. Mullen would meet with the cash flow committee?
Yes, sir.
What was his role?
Just as an advisor, that my father felt like he could do a better job of potentially negotiating with some of the vendors, et cetera, for extended payment terms.
In this 2011 timeframe, was there a member of the committee that was dealing with the sales tax issues?
I believe it was Diana Wee that was, yeah,
She was still with the company then?
I believe so.
Okay. So she'd been vested with full responsibility to discuss the issue of sales taxes with the department and come up with payment arrangements in 2011?
Yes, sir. I believe that's correct.
And during the time you were president, that was in regards to the sales taxes, thus that's the role she undertook?
Yes.
What was Diana Wee's title with the company? What position did she have? Do you remember?
I know that she was hired as the controller, and I believe that her official title shortly after that became CFO.
After the time this cash flow committee was constituted, about how often did it meet?
Once a week. Sometimes it could be a couple times a week, just depending on the severity of the cash flow.
But at least weekly?
Yes, sir.
So the committee would discuss vendor or tax issues as the case may be?
Mostly vendor issues, yes, sir.
The tax issues were again left to Ms. Wee?
Yes. Other than, as a correction, other than we knew because of the forecasting, we would try to put money aside every week to make that monthly payment. I believe it was a monthly payment. So we knew that there was an obligation and that X amount of dollars needed to be put towards taking care of that obligation.
In the year 2011, was the company's, I think you described it as backlog, continuing to decrease?
Yes.
By backlog, I would refer to that as, well, it's not really work in progress, but the work that is going to be in progress?
Yes, sir.
Okay. So the committee would make decisions as to payment of vendors, correct?
Correct, yes.
Did the committee make the decisions as to payment of sales taxes, or again, was that something that was left to Ms. Wee to negotiate?
To my memory, it was left to Ms. Wee to negotiate because, we understood the severity of paying. It's like paying your power. You have to. Mm-hmm. There were certain things that absolutely had to be paid. The employees, electric, utilities, things like that we just had that were non-negotiable. And I believe that the sales tax was one of those things that was really non-negotiable.
When the committee, this cash flow committee, made a decision as to how a particular vendor was going to be handled, would it designate someone to deal with that particular vendor in that manner?
Whoever had the relationship with that vendor, yes, sir.
In regards to payment of vendors, if the committee decided to proceed in a certain way, Did you ever make a different decision and proceed in a different way?
Not to my memory, no, sir.
So would it be fair to say that you felt you were bound to honor the decisions of the committee?
Absolutely. I mean, if at the end of the day, I suppose that I could have said, no, pay Jim, not Jane, or vice versa. But I felt all along that if we weren't a team, if we didn't have a collective agreement, or if I didn't honor that collective agreement, that team spirit, it was a difficult time for everybody. And that I would break that. If I wanted to go left and they wanted to go right, that I would break that trust or that hard work that they were doing to try to salvage the company.
Now, if you came to a payment arrangement on sales taxes that required something to be signed, would Ms. Wee prepare the form and just ask you to sign it?
To my memory, yes, yes. I do remember signing those agreements.
You didn't personally prepare any of those forms, did you?
No.
Mr. Lortz, have you ever been a shareholder of the company?
No, sir.
Now, at some point in late 2011, I think the creditor was named Celtic or Celtic Capital, something along those lines. They actually filed a case in the Kern County Superior Court to appoint a receiver. Is that correct?
Yes.
The appointment of, was Mr. Mullen still representing the company at the time of this receivership case?
Yes, absolutely.
Did Mr. Mullen recommend that the company consent and not oppose the receivership?
I wasn't really part of those discussions, but I believe if somebody would oppose it, it would have been him.
Who was part of those discussions, to your knowledge?
To my knowledge, it would have been my father and Mr. Mullins.
Did you have a chance to discuss with Mr. Mullen the payment of the company's bills that would happen through the receivership?
Yeah, so when they told me that the company was going to effectively shut down, I knew that there were some employees that, we had payroll that was coming up in a few days, right? And, how do these employees, I grew up with these people, how do these, not only, and a lot of those people had worked with us 20 plus years, and it was a difficult time, and I said, well, how are those people going to get paid? And and he said through the receivership that there would be a claim filed and they would promptly get paid. And I asked about, and I didn't know any of this, but Mark Hafner, who was the CEO or maybe the president of Celtic Capital, him and I became, I guess, fairly good. He acted like a father to me, and he said, Nathan, he goes, this is going to get really rough for the company. When the gates close, he said, you need to make sure that, he goes, I can see your books, and there's sales tax. He goes, you need to make sure that sales tax gets paid. So I went to Mr. Mullins and I said, how are we paying? Because we didn't have enough cash, right, that second to pay all outstanding sales tax. How is that getting paid? And he said, don't worry, there'll be, there's $1 million worth of receivables that will be collected. The assets of the company are valued at probably $4 to $5 million. There, so you add up the debt versus the asset, and there would be more than enough money to pay those sales tax.
So in summation, you believe, and Mr. Mullen told you, that any sales taxes that were owed by the company would be paid through the receivership?
Yes, sir.
Do you have any recollection as you sit here how much was owed in sales taxes at the time the receivership case was filed?
I didn't know at the time. I mean, looking back through the documents that, when all of this has been tried to get settled, I think it was $100,000.
Do you recall the approximate date that the company actually ceased operations?
October 2011, maybe October 10th, 2011.
So based upon the values of the receivables and the hard assets of the company, did you believe at the time the receivership case started that those assets would be sufficient to pay all creditors of the company?
Yes.
At some point, I mean at any point, did you become aware that your father had received about $500,000 from the receivership case?
A couple of years ago, as we were going through this case, I had learned that that he received money, the leftover funds after everything was paid.
In the receivership case, were the wage claims paid to the employees, to your knowledge?
To my knowledge, yes.
In the receivership case, were there any sales taxes paid out to the department?
I don't believe so, or I wouldn't be here.
Oh, we wouldn't be here. That's true. Were you paid anything at all, Mr. Lortz, from the receivership case when it concluded?
No, sir. It wasn't my company, it wasn't my money. I didn't have rights to it.
I have no further questions at this moment.
Okay. CDTFA, do you want to ask questions of the witness?
No questions, Your Honor.
Co-panelists, do you want to proceed with questions?
I don't at this time.
I do not have questions.
Okay. I have some questions. Mr. Lortz, I guess I want to ask some more about what authority you had vis-a-vis the committee. I understand everything you said, that the committee was mostly making decisions about paying vendors, and you said that you knew you needed to set aside some money for the taxes.
Yes, ma'am.
Okay. Can you explain to me what does that mean? And
So basically, I can't remember who created the Excel sheet, but we had inbound revenue that we were collecting, as we completed jobs, as our customers paid us, and we had liabilities, which were lights and wages and taxes and all of those things. And so basically we would try to do a forecast as long as we could, 4, 6, 8, 10, 12 weeks, and knowing where all of those things would populate. So for example, if we had an agreement with Joe's Steel Company, that we would pay them $10,000 a month because we owed them $100,000, then we would populate that in one of the columns. So we would see what our weekly projection of inbound money would be and outbound money. And so a lot of times, the team did a really good job of balancing that. And so there was no decision that ever had to be made. It was just, okay, we forecasted this, the forecast is correct. We go on to the next week and next week and next week. And then if we see something in 4 to 6 weeks that is possibly a problem, okay, well, we got to figure out how to renegotiate or let Joe know that, hey, we need one more week because this check that's supposed to come in for $500,000 from our customer is delayed, isn't going to come in, or wasn't sent when it was promised. So there was little things like that that would move from week to week, that basically allowed Mrs. Wee to cut all the checks that needed to be cut for the company. Does that answer your question?
Well,
Sort of.
I guess I wanted to figure out more about whether, as we discussed at the beginning, you concede that you knew that there were taxes not being paid, that there were some taxes that were not being paid. And I'm trying to figure out, could you have exercised your authority as president to get those taxes paid?
Well, to my understanding, ma'am, Your Honor, it is that those were the documents that I had signed. Those were the payment plans that we were paying the state of California. So, and part of that is, okay, you have to stay current with your current taxes, but these taxes that are past due, we need to pay these back. And those were what the documents that Mrs. Wee negotiated with the state of California that I had signed.
So you thought that took care of all the payments of the taxes?
Yes, ma'am.
At what point did you learn that there were sales taxes, that there were some sales taxes that were not being paid, that were unpaid, that there were some sort of sales tax liability owed?
Well, again, I thought that all the sales tax, we had agreements to pay that. And so I only became really, I guess, ultra concerned with that when I knew the company was going to shut down. And how do these sales taxes get paid? Because, again, I thought that we were current on the payment plan with the state that was previously agreed upon by Mrs. Wee.
Did you ever learn that the company was not keeping up with its payments on those sales tax, those payment plans?
No, I thought that we were current until the day the company closed the doors.
I have other questions, but I'll ask Mr. Lortz, and then I'll say your attorney may want to. I don't know if you want to address it or your attorney wants to address it. It's more about something that I saw in the briefs that were filed. There was an argument in one of the briefs that said that Mr. Lortz by himself didn't have authority to pay more than anything beyond $5,000. Is that correct?
Yeah.
On your own signature without.
Right. I can't. If the company had $1 million to pay Joe Steel Company, and that was approved and all of that, I could not sign that check. I could sign a check up to the amount of $5,000, I believe, and after that, then it was two people had to sign it, myself and I think it was Mr. Coffey and or Mrs. Wee.
Was that just unofficial procedure? Was that in the bylaws somewhere? Just the way it.
That's just the way I was told
Okay.
how it worked.
So then, how did you have authority to sign the installment payment agreement, which was for more than $5,000?
That's a good question. I mean, it said that Mrs. Wee brought the documents to me, and she said, because I knew that we were behind at, let's say, 2009. I'm sorry, it's been so long,
Sure.
I might get days mixed up. But she says, I've negotiated with the state of California because we're 5 or 6 days behind, and we're going to get further behind if we buy what it looks like. We just don't have the cash to pay this right now. And she said, you just have to sign this to basically it was an agreement. It wasn't a check. It was an agreement to pay those taxes for the company, on behalf of the company.
Okay. I think that's all that I have at this time. And if no one has anything further?
I just would like to indicate that I may have questions for the appellant after the department gives its presentation.
Okay, I understand. All right, then, if everyone's ready to go forward and no one needs a break, then I think we can go ahead and hear CDTFA's presentation.
Okay, thank you. At the outset, as part of appellant's argument addresses the July 2011 and beyond, we'd like to note that the July 2011 late prepayment penalty, along with the January 2010 failure to prepay penalty, are no longer in dispute because the Appeals Bureau recommended removal of those penalties. As you're aware, 4 elements must be met for personal liability to attach under Section 6829 of the Revenue and Taxation Code. First, the corporation must be terminated. Second, the corporation must have collected sales tax reimbursement. Third, the person must have been responsible for payment of sales and use tax. And fourth, the person's failure to pay must have been willful. In this case, appellant has conceded that there's no dispute as to the first 2 elements. Both parties agree that Lortz & Son closed in 2011 and that it collected sales tax reimbursement. As to the third element, whether appellant was a person responsible for the corporation's payment of sales and use tax, there is ample evidence that appellant was a person responsible for handling Lortz & Son's sales and use tax matters throughout the liability period. Responsible person means any person having control or supervision of, or who is charged with the responsibility for, the filing of returns or the payment of tax, or who had a duty to act for the corporation in complying with any provision of the sales and use tax law when the taxes became due. In this case, we have evidence that the appellant was listed as president in a board of directors meeting minutes from November 2007. Appellant is listed as the president and signed as president. That's Exhibit C, page 339. We also have ACMS notes from the appeals conference in which appellant stated he became president around April 2007. And we have documentation in a financial summary on Exhibit C, pages 29 to 31, that the appellant received officer compensation of $6,000 biweekly. Now that we've established appellant was the president of Lortz & Son from 2007 through the close of business operations, we can talk about how he signed the following documents as president of Lortz & Son. Sales and use tax returns for the second quarter 2007 and fourth quarter 2008 periods. That's Exhibit C, pages 84 to 85. A May 4th, 2010 installment payment agreement, Exhibit C, page 90. A June 16th, 2011 installment payment agreement, Exhibit C, page 115. A June 1st, 2011 letter to the department regarding the company's outstanding sales and use tax liabilities, Exhibit C, page 118. A September 30th, 2011 Union Bank Depositor Agreement authorizing appellant as a signatory, Exhibit E, pages 5 through 6. A March 4th, 2010 Power of Attorney Authorization Form, Exhibit C, page 87. There is no argument or evidence that appellant's duties changed during his time as president. Appellant has repeatedly told us that he was involved in a committee making weekly corporate financial decisions. This in his opening brief, pages 7 through 8, Exhibit C, page 38. And during the May 16th, 2000 appeals conference, Appellant conceded that he had authority to make decisions regarding which liabilities to pay and did not pay the tax liabilities. That's Exhibit D, pages 2 through 3. Appellant's role was confirmed in conversations the department had with at least 3 former employees, each of whom described appellant as participating in financial meetings and making decisions regarding who should be paid. Exhibit C, pages 44 and 48, Exhibit E, pages 23 through 27, and page 29. Based on our evidence, appellant, as president of Lortz & Son, was responsible for handling and had a duty to act with respect to sales and use tax matters. Appellant argues that he was appointed as president without any formal corporate action, and his title of president was not official because his father never really stepped down from running the business. However, this argument is contrary to appellant's own statements today that his father did not want to participate in the financial decisions and that appellant had authority to determine which creditors would be paid. Exhibit A, page 5, lines 8 through 17, and Exhibit D, pages 2 through 3, as well as statements from former employees that appellant was the final word in making financial decisions for the company. You can find that at Exhibit C, page 48, and Exhibit E, pages 23 through 28. As to the fourth element, whether appellant's failure to pay was willful, the evidence establishes that appellant's failure to pay Lortz & Sons tax liabilities was willful. Failure to pay is willful if the person had knowledge that the taxes were not being paid and had the authority and ability to pay the taxes, but failed to do so. As to knowledge, appellant has conceded that appellant was aware that Lortz & Sons taxes were not being paid. As to the authority to pay taxes, the evidence shows that throughout the liability period, appellant indeed had authority to pay. Examples of this evidence include appellant's own admissions and statements of former employees that appellant directed payments of the business's liabilities, which I referenced above, as well as appellant's title as president, check signing authority, involvement in the 2 installment payment agreements, and other communications with the department regarding the sales and use tax liabilities, the letter I referenced earlier, showing that throughout the liability period, he had the authority to pay. Exhibit E, pages 7 through 22, also show copies of the Union Bank business checks from March through September 2011, signed by appellant only, at least 5 of which were over $5,000, including one for over $27,000, which contradict appellant's statements in his opening brief and today that he was not authorized to sign checks exceeding $5,000, as well as the installment payment agreement, which you referenced. Appellant has argued that it's unfair to hold him personally liable because he was following the advice of the committee when he chose not to pay the corporation's tax liabilities. However, his decision to follow their advice does not relieve appellant of his authority or duty as president to act on the sales and use tax liabilities. Finally, as to the ability to pay taxes, the evidence shows that Lortz & Son had funds to pay the taxes, but used those funds to pay other creditors instead. For example, the business's Union Bank account statement shows a balance of over $286,000 on January 30th, 2010, the day before the fourth quarter 2009 taxes were due, and over $1.6 million on February 26, 2010, 2 days after the January 2010 prepayment was due. It's Exhibit C, page 400. Over $3.9 million moved through the business account from February through April 2011 alone. It's Exhibit C, pages 125 to 147. Payments were made to 2 suppliers from fourth quarter 09 to second quarter 2011, totaling over $439,000. It's Exhibit C, pages 76 to 82 and 98 to 107. And an EDD wage summary shows that Lortz & Son paid over $9.3 million in wages during this period. Exhibit C, page 112. All of this evidence shows that there were available funds to pay Lortz & Son's tax liability, but the funds were paid to other creditors instead. Appellant implies that based on the installment payment agreement, he cannot be found willful. However, neither the regulation or statute provide that entering into an installment payment agreement discharges a responsible person from willfulness. Furthermore, in this case, Lortz and Son did not fully comply with the installment payment agreements. Based on all of the evidence provided here today, the department has clearly met its burden of proving all elements for imposing personal liability to appellant. For these reasons, we request that the appeal be denied. Thank you.
Panelists, do either of you want to ask questions of CDTFA?
I don't have any questions for CDTFA. However, I think I will have questions for appellant, but I want to give counsel an opportunity to elicit any additional factual information he may wish to on rebuttal before getting to an argument. If he intends to elicit additional factual information, I will wait for him to do that before I ask my questions. Otherwise, I'm prepared to ask now.
Okay. Actually, I have a question for CDTFA. I'm aware, of course, of third-party taxpayer confidentiality requirements, so
Yeah.
I'm asking this with full awareness. But I wanted to ask about how much has been whether there's any amount that's been collected on this liability so far, because the amount, we essentially will want to know the amount that's in dispute here.
We're not aware that any of the liability in dispute has been collected.
Okay. So it's the full amount
Correct.
at this time.
Other than the two penalties that I mentioned at the top of my presentation.
Okay. All right. Second.
Excuse me,
Yes, go ahead.
may we make one additional point?
Yes, go ahead.
Okay. Appellant also referenced the receivership, and I'd just like to note that CDTFA did file a lien, but we were told by the receiver there was a superior lien. So we did not, we pursued that, but we were not able to collect in the receivership.
Okay, go ahead.
For the department, you were informed by the receiver that there was a superior lien. Did they identify who the superior lien holder was?
Let me see. I believe, yeah, they did. In Exhibit C, pages 237 to 243, gives the response from the receiver in relationship to our lien. You can also find in Exhibit C, I can reference you the pages if you'd like, our progression of pursuit in that lien. But we have lots of tools with which we use to collect, and that's one of them. But we were not able to collect through the receivership.
Were there multiple superior liens, or just one superior lien?
I believe there was just one superior lien. Do you mind if I look at that page? And
If you can just tell me who the company was so that I don't have to go through Exhibit C.
it was not a company. It was the individual that the appellant mentioned. It was Charles Lortz Sr., who was the superior lien.
Okay. Thank you.
Or it's Charles Lortz Jr. Apologies.
Thank you.
And just
right.
so the record's correct, actually the superior lien holder is the people who filed the receivership case, which is, if you looked it up in the Kern County docket, it's either Celtic Capital or something like that. They had the number one lien position because I think they were receivable financers. That's what I understand that they were, basically a factoring company.
All right. Then at this time, I will say that if appellant has any questions about CDTFA's argument, you can ask questions, and if not, you can proceed with your rebuttal.
Well, it sounded like a pretty good closing argument to me from the CDTFA. That's sort of how I took it. But I wanted to ask Mr. Lortz, I just had just a couple of questions, no more than a couple, of what came up in the CDTFA's presentation, if that's okay. Okay. I'm getting a nod. Okay. Mr. Lortz, the CDTFA attorneys were talking about some checks that were written for over $10,000. Mm-hmm. And you testified earlier that those, or over $5,000, those would have required a second signature. Is that correct?
Correct.
Now, if I could find, should I have the page reference at hand, counsel? I'm sorry.
Let's see.
I had it open, then I turned away from it.
The pages are 7 through 22 of Exhibit E.
Okay, very good. Thank you. Thank you very much. Now, Mr. Lortz, there are some checks here that are written for over $5,000, correct?
Yes.
What was your understanding as to the need for a second signature on those checks?
Well, a lot of times I would get the checks first. Sometimes it was second, but I would sign them but knew that anything over $5,000 had to be signed by Mike Coffey or Diana Wee.
Okay. So any check that's over that $5,000 amount, it was your understanding at least that it was supposed to be countersigned as well?
That's what I understood. Yes, sir.
I think that's the only. I think it'd be repetitive of my earlier questions to go into some of the other issues. I think I'll leave it at that.
Would this be a good time then for me to ask a few factual questions?
Go ahead.
Thank you. Mr. Lortz, you started working in sales for the company when you were 27?
Yeah.
Is that correct?
Well, I mean, I think I was first employed by the company at 13 or 14 years old. But yeah, and I worked out in the shop, but after I think I came back to the company when I was 27.
And did you? What else did you do employment-wise prior to going to work for the company at age 27?
I worked in various jobs in like civil engineering, like heavy earth moving, stuff like that.
Are you an engineer by education?
No, sir.
Okay. So when you were appointed as president of the company in 2007, did you ask your dad why he was appointing you?
Yes, I thought I responded to that in this hearing, but so how it was explained to me is that with the title as president, it would be easier for me to engage with larger customers, where if at the 11th hour of a discussion or a negotiation of a contract, that I could say, it was embarrassing to get all the way to the end of a meeting with a large customer and them say, well, we want better payment terms, or we want faster delivery, and me say, well, I have to go back and ask my dad. And so it was just more of a figure piece to say, I could close that deal with them, that they felt like the customers would respond better to that they were talking to the guy. It's like if you called Microsoft tech support or if you called Microsoft Bill Gates, right? The difference of feeling like you had that direct connection to the company.
Were you the guy?
I was the guy when it came to getting things done in sales or in production. Obviously, we grew the company. I worked very hard to grow the company in bringing new orders to the business and improving efficiencies in the shop. I'm not an accountant. I'm not a financial whiz. I grew up welding and working hard, and I wanted to take what my grandfather and father had worked their whole lives and finish it, keep growing it. I have 2 young boys, and the sad thing today is that, number one, we've lost the family business, and that's a tragedy for California, right? If you talk about a company bringing $30 million a year in tax base and a couple hundred jobs, it's a big deal. It's a tragedy, right? And we did everything we could to keep the business afloat. But at the end of the day, I'm just working for wages now. I wasn't a shareholder. I didn't own the company. I didn't receive any benefit from the company, any of those things. And today I have a job, right? Which I have no idea how I would pay off $200,000. It'll destroy my family. I have 2 young boys that I'm trying to raise and grow, and I told my attorney, I said, at the end of the day, I don't think like ignorance is in a defense. I really don't. Did I get myself in a position where I shouldn't have been? Absolutely. But you guys talk about, I listened to the counsel of the company, our attorney say, well, the sales tax will be taken care of. It'll be paid. Okay, so the receivership goes through, and I didn't have anything to do with that. But at the end of the day, my father walks away with $500,000 and doesn't pay the sales tax. Why am I sitting here in front of this board? I wasn't the one that ended up with the money to afford to be able to pay this. It wasn't my company. Why am I the person here? That's it.
Were you making $6,000 biweekly when in your sales position too?
Yes.
Who did your dad stayed on as CEO
Yes, sir.
after you became president?
Yeah, he was the same role.
But at some point, I've heard in your testimony, and I read in some of the documents, your father was withdrawing from active involvement in management of the company?
No. So it was my father's business. My father didn't like dealing with problems. My father liked building stuff in the shop and going to lunch with his friends. And so when there was problems, for example, in 2009, Diane, we knew the company was, the backlog was shrinking. We were getting tight on cash flow. I said to Diane, I said, we need to come up with a plan. We can't just close our eyes and hope this is all going to get better. And so part of the plan that she came with was a reduction of 30% of the employees. So we took that plan to my father and said, look, this is what we have to do. If we want to live to we have to trim the tree, right? Or the tree's going to die. And he said, I don't care. He said, run it till the wheels fall off. I'm not firing any employees. I respect that. I mean, he had respect for his employees, which you don't see a lot of today. But so I can't override him. I can't say, well, you're wrong. I guess I could have quit and left the business, but it's kind of hard to do in a family business.
As president, you answered to him as the CEO?
Yes, sir.
And did the people on the committee, they were inferior to you in the pecking order of management?
Sure. I mean, I was the boss's kid. So, yeah. Equal to, or, I mean, like Diana let me say this. Diana reported directly to my father. If you looked at an org chart, that reporting line didn't come to me. Gene Polk or Joe Grenier, the head of the product value team, I think he was equal to me. We were on the same line as in the org chart, if that makes sense.
Thank you. Those were the only questions that I had.
Okay. I think I have a few follow-up questions. When we were discussing what the issues are, we confirmed at the beginning that appellant concedes that he had knowledge that the taxes at issue were unpaid. But then that seems to contradict what Mr. Lortz's testimony was. Earlier, Mr. Lortz, it seemed to me like you were saying you didn't know that the taxes were unpaid.
Well, I knew that they were unpaid in the sense of that we were in I believe we were in a payment plan to pay those unpaid taxes. So maybe that's just dicing the word up, or maybe I'm saying that wrong, but we wouldn't be in a payment plan if we'd paid our taxes, I guess. So yes, in a sense, I knew there was unpaid taxes. I thought that we were taking the correct steps to rectify that and had an agreement with the state of California. And ultimately at the end, I thought that the receivership would have to pay those taxes. That there was nothing more, I guess, as you guys stated, as a superior position, whatever that means. What can be higher than paying the state, right?
Okay, so your knowledge was just based on the fact that you knew that the company had entered into these installment payment agreements?
Yes, ma'am. Yes.
Okay. Let me go back to CDTFA about the installment payment agreements.
Yes.
Ms. Jacobs, you indicated that the company at different points did not comply with the installment payment agreements.
Correct.
I'm sure it's in the evidence, but can you walk me through when there was noncompliance?
Sure. So it's indicated in the letter. Let me find the page number. Apologies. It's indicated in the June 1st, 2011 letter, Exhibit C, page 118, that the first installment payment agreement was canceled because of a request not to make payment and a request to skip payment. So then that's when the June 2011 installment payment agreement was entered into. And there was Can you hold on a second? Can I confer?
Sure, yes.
No, there's two side copies. Yeah,
This almost looks like my father's handwriting, but maybe it was Diana's. So if you look here.
So there was a partial payment in July 2011, which the penalty itself is evidence of, in which they paid $304 instead of $19,804. And then there were September and October payments that
September and October.
September 2011 and October 2011 payments that bounced, but those are outside of the liability period.
Right, I was just about to ask.
So we didn't, submit. We have evidence that it was not submitted because it's outside of the liability period. We're not asking for,
Yeah, so if it's outside of the liability period, in terms of making my findings.
Yeah, it's still related to it's related to those payments, but.
What was the date of the receivership?
The date of the receivership, I believe, was October 19th, 2011 is when they entered into the receivership.
Okay, so you're saying it was a non-payment that occurred before the receivership?
Correct.
Okay.
If I may add, I believe the second installment payment agreement was entered into after any unpaid taxes or penalties that are still in dispute in this appeal, so I don't know how
That's true.
how relevant that is.
Well, so I'm trying to narrow down what which exactly are the unpaid taxes that he was aware of at where there was noncompliance with the IPA.
So we have evidence, appellant's own admission that he participated in the weekly meetings of the corporate financials, including discussions on the sales and use tax liabilities. So I can point you to that evidence, which is the opening brief, pages 8 through 9, Exhibit A, pages 5 through 6, and Exhibit D, pages 2 through 3, as well as testimony of several former employees that stated that the appellant was kept apprised of the sales and use tax liabilities.
Right.
So Exhibit C, pages 44 and 48, and Exhibit E, pages 23 to 27, and page 29. It's also for responsible person liability. They had the duty, the authority, and the ability when the taxes became due. So it's our position that an installment payment agreement does not discharge someone of willfulness.
So you're saying that, and I do recall you made this argument at the beginning, but I just want to confirm. You're saying that even if the company was in complete compliance with the IPA, that there could still be responsible person liability in this case because the IPA in and of itself existed and it wasn't paid off?
Yes, and we have the additional argument. I think you're aware that the prior board treated an IPA as a get-out-of-free card, but that's nowhere in law. It's not in regulation. It's not in a statute. And so we wouldn't concede that someone who complied with an IPA automatically couldn't be held responsible.
Mm-hmm. And I guess I understand that there's two prongs to this argument.
Right.
One is that what we were just discussing, and the other one is, even so, you're arguing that there wasn't compliance with the IPA.
Correct.
But I want to make sure I'm covering all the bases here.
Correct. Yeah, there were broken promises, like the initial IPA, the May 2010 IPA, that was canceled. That promise was canceled because of failure to make payments, which appellant references in the June 1st, I think it's June 1st letter.
Okay. Let's see. I think those are all of my questions at this time. Do my co-panelists have any further questions?
No.
Okay. Okay, I'm trying to make sure I've covered everything. Right. Yeah. Okay, then I'm going to say, Mr. Brumfield, does appellant, I think you had indicated you wanted to make some additional argument or statements?
A couple of the exhibits that were raised by the department's presentation, I just had a couple of questions about to get on the record, not a lawyer's couple, just maybe 4 or 5 questions, if that's okay.
Okay, go ahead.
Mr. Lortz, I'm looking at Exhibit C, page 115. It says page 115 of 416 is how it's labeled. Installment payment agreement. Appears to me it's by your signature. It's dated June 16 of 2011. Do you see that?
Yes, sir.
Did you prepare any of the content of this agreement?
No.
Who prepared this?
Diana Wee.
I see a schedule of installment payments near the top, and it says I agree to make payments of $5,000 every other Friday beginning July 1, 2011. Do you see that?
Uh-huh.
Is that something that Ms. Wee had negotiated?
Yes.
Had you negotiated that?
No.
The handwriting on this, the signature is yours on this document,
Yes, sir.
correct?
Yes.
The handwriting, do you recognize who the handwriting is?
It's Diana Wees.
And you didn't prepare any of the terms of the agreement or the schedule of payments?
No, sir.
Portion? Okay. On page 118 of Exhibit C, there's a letter dated June 1, 2011, addressed to the State of California Board of Equalization to a Ms. Deanna Lorenzana. Do you see that?
Yes, sir.
This appears to bear your signature, is that correct?
Yes, sir.
Did you prepare this letter?
No, sir.
Who prepared this letter?
I believe it was Diana Wee.
Looks like it's talking, near, right above your signature, about 2 paragraphs up, is talking about a payment arrangement for a balance of $143,732.76. You see that?
Yes, sir.
Is that something that you negotiated, this payment arrangement?
No,
mentioned?
it says right there, per your discussion with Diana Wee.
And Diana had engaged in those discussions, to your
Yes, sir.
understanding? Okay. I think that's all I had.
Okay. Does anyone have anything further then? Okay, no? All right, so at this point, we can conclude the hearing and close the record. I would like to thank everyone for,
Unless you want to have closing argument.
oh,
And you may or may not, I don't know.
I guess I thought that everything was covered. If you have additional argument, I'll hear it, but I thought that we had covered everything.
I asked you to elicit your factual information, and then we would ask some additional questions, which we did. I have not yet heard any rebuttal argument from you, except maybe a few words as you were eliciting additional information from your client. So I think probably if you wanted to take a few minutes in rebuttal, that we would allow that.
Yeah, yeah, I would allow that.
Okay, that's.
I thought you had made your argument.
Well, in essence, perhaps, I was thinking of more of in terms of a trial presentation where people make closing arguments and someone responds, and the CDFTA's presentation was really just an argument, and so that's sort of how I took it.
If you'd like to make argument on rebuttal, you can proceed.
I'll try to keep it succinct, though, for everybody. First, of course, want to thank the panel for being here today. There are a few matters.
Oh, and I will just confirm, I rescind what I said about closing the record. We're still on the record.
That's right. Keep on typing. Thank you, panel, for being here today. There are just a couple of matters I want to focus on. First, this is not a case where the company or my client, Nathan Lortz, engaged in actions that equate to an abject failure to pay sales taxes. Throughout the periods in question, I think it's been made clear that payments were being made, regular open channels of communications were with the department, installment arrangements were made, payments were made, and so forth. This is not a situation where the taxpayer, as is often a taxpayer in similar situations I have seen, and I'm sure you have seen, simply sticks their head in the sand and says, forget it, I'm not paying, I'm not communicating. I'd reference the installment agreement at page 118 of Exhibit C, and at least in the records that we have, which are unfortunately only the ones that the department can provide because Mr. Lortz does not have access to any financial records, nor do we know where they are. If you look at the bank statements on page 139 of Exhibit C and 146 of Exhibit C, they show significant payments being made. Those 2 months alone, about $110,000 to the board, to the department. So and one of the payments, $56,000, was the exact amount that had been agreed to in a prior installment agreement. Now, I don't know what payments were made after that. I say I don't have the bank statements. I do want to comment on something that the department brings up. They bring up some arguments in a brief that was filed. Arguments aren't evidence. Just as me saying here right now and arguing is not evidence. It's not an admission of anything, and it shouldn't be taken that way. It is absolutely zero evidentiary value. Now, and I also want to discuss briefly the weight of the evidence. I know that you're not bound by specific hard rules of evidence as if we were in a California state trial court. I understand that. But I don't think that it is really appropriate for the OTA to base its decision on unsworn statements of Mike Coffey, who concludes his statement when you read it, of, I got to get off the phone, I'm not filing anything, I'm done with this thing, I'm owed money, is in essence what he says. Or Diana Wee, or Jean Dolk, or Cynthia Schnauer. Now, as to the weight of the evidence, somebody saying something to an employee of the department who then relays it and you're trying to take it at face value, that's quite frankly double hearsay. I mean, these people aren't even submitting declarations. I mean, if they were submitting declarations, I might feel differently. Quite honestly, to not state the phrase in full, I think their statements are basically their own CYA. There's no doubt about it. The testimony of Mr. Lortz makes that very clear. Third, I don't know how to comment, and I'm not saying that the state should have gone wild in the receivership case to try to collect money. That's not their obligation. I'm not going to say it is. I mean, I would have liked it if they did, but they don't have to. But I find that case a complete mystery as to why the receiver is paying employees who don't hold a secured lien, but not paying sales taxes who don't have a secured lien, and then returns money to Mr. Lortz, but the order that was referenced says it's being returned to the company. It's baffling. The company had more than enough money to pay the sales taxes at hand. No fault of Mr. Lortz, who's sitting here at all. I think we've covered some of the elements of 6829. We've certainly gone through them, and I think that the committee involvement is telling. What Mr. Lortz's actual role was in that committee and role as president, I think clearly does not establish any kind of willfulness, certainly, based upon how the company was set up to be operated and the payment of the taxes. There's no intentional, conscious, or voluntary course of action not to pay the taxes in question. And I think Mr. Lortz is entitled somewhat, and I know the law is tilted in the department's favor as to finding liabilities. But when you rely on a group of professionals, including a corporate lawyer and the longtime owner of the company, and act in compliance with that, that seems to me to be absolving right there. And that would be my reference probably to 18 California Code of Regulations 1702.5. At the time, and all these statutes, the 6829 and 1702.5, all reference not paying taxes at the termination or conclusion of the business. Mr. Lortz left the company in a position where those taxes should have been paid. You know, the receivership coming in is nothing more than almost another committee directing how things are going to get paid. I don't know what the receiver did. Quite frankly, I would have never consented to a receivership if someone would have asked me. I'd have said, put this thing in a Chapter 7 where taxes have a high priority and you're going to get paid, and Mr. Lortz wouldn't be sitting here. I think that was just terrible advice, but obviously those were decisions made 8 years ago that we can't change. But we certainly can look at the intent of Mr. Lortz and whether he even had control to be able to pay the taxes at that time, and he didn't. I think on the Revenue and Taxation Code 6592 issue, which talks about the failure to make payment or file a return is due to reasonable cause and circumstances beyond Mr. Lortz's control and occurred notwithstanding the exercise of ordinary care and absence of willful neglect. I think that's been made obvious by the testimony, which is uncontradicted, by the way. And certainly uncontradicted. The only thing it's contradicted by is double hearsay statements. But there should definitely be relief from the penalties, absolutely under 6592. And we think that should tie over to the taxes as well, and the responsible person liability should not be found. Thank you.
Okay. All right. Now, does anyone have anything further?
Nope.
Okay.
No.
Okay. All right. If no one has anything further, then at this point, I will say that we can conclude the hearing and close the record, and I'd like to thank everyone for coming today. Following the hearing, my co-panelists and I will discuss the evidence and arguments, and then we will issue a written opinion within 100 days of today's hearing.
Okay.
Thank you all very much. The record is now closed.
Okay, thank you so much.